don't mind my police award. I'm going to give this to the police award for the biggest cock. So whichever cop ends up being the worst cop out there, I'm going to send this to the cunts for the biggest giant blue cock award. It's apparently some Warcraft figure, some orc's cock or something, but just thought I'd throw that in for a bit of humour.
Oh my gosh! All right.
Yeah.
Anyway, yeah. No.
No, I don't sit on it. It's far too. Yeah. Huge.
You sure? Because it's already bent.
Well, it's really funny when you're walking around the house with this holding on. Honey. No,
oh gosh.
Done with it though, I'm sure. Anyway. I remember you telling me something about secondary legislation and primary legislation, and when you hear a lot of people going on about the COVID acts and stuff, they go on about primary and secondary, but that's a different type of primary and secondary, isn't it? That's the
okay. So what you're talking about when it comes to that kind of thing is when you're talking about the COVID Health Response Act, okay, that's the legislation. But then everything when they do their health orders under, I think that's Section 11, okay, those are subordinate mandates.
So they're secondary to the primary act, but it's not sort of the
well, I suppose since I'm learning about the Imperial Laws Act, I suppose the way you could look at it is every other act is secondary, and then you've got secondary subordinate legislation within it.
Yeah, that makes more sense.
Because yeah, I mean it's sort of like it goes 1, 2, 3 basically. But you've got the primary one. Like I just had a little bit of an email war with a government organisation in regards to that. And when I sent it back stating that they're trying to circumvent the Imperial Law Application Act 1988 and put a few other paragraphs under it, I haven't heard back from them.
Yeah, because weren't they getting their jurisdictional primary and secondary jurisdictional things a little out of whack?
Oh, I mean, what it comes down to is they believe that their legislation is primary jurisdiction. Yeah, primary legislation, primary jurisdiction. But it quite clearly says in the Imperial Law Application Act, it's 6A subsection 2, everything else is secondary legislation. Doesn't say secondary jurisdiction, it says secondary legislation. Yeah. So therefore,
they're already in the secondary jurisdiction to begin with, because the primary jurisdiction 1520 Te Mawanu Anui Akiwa, isn't it?
Well, exactly, yes, exactly. So, but I mean, they don't want to listen to that because it takes away their jurisdiction to deal with the matter. However, the organisation that I'm dealing with at the moment, my next question to them, if they do turn around and reply, is, so who has judicial capacity? Because I don't believe any of them will have a judicial capacity, because normally it's an arbitrator or a mediator, and there's no judicial capacity.
Okay, so because what were you saying about the settler and appearing as a...
Oh, the non-resident settler. Yeah. Yes. So the non-resident settler, my understanding of that is, if you're a non-resident settler and you go to court, a non-resident settler can set up a public trust under the Public Trust Act, and so therefore you can turn around, like if you're in, depending on what court you're in, you just assign the duties like administrator to the judge, fiduciary to the registrar, and then whoever the other party is, they're the trustee. So all you're really doing is turning around and taking like how you would with a will. You've got your trustees. So your trustees are responsible for executing the will, okay? Right. And the administrator is responsible for telling the trustees what's got to be administered from the will, and like that. Yeah. So at the end of the day, you become the non-resident settlor, which means you are the one telling the administrator, which is the judge, what to tell the registrar to do and the trustee to do, because the registrar becomes the fiduciary.
Right. That's perfect.
Yeah. So what you're basically doing is you're turning the court or the judge into your agent as the principal, because the principal is within the courtroom. The non-resident settlor it's settlor, not settler.
Okay.
Yeah. So you're there on that particular time. You're making a special appearance to settle the matter as the non-resident settler. So you're telling that you're assigning the judge as the administrator, then you're assigning the registrar as the fiduciary, and then the other one's the trustee. So the administrator's got to tell the fiduciary and to tell the trustee to, you know, because the trustee becomes liable for whatever is put in front of the court.
Sure. So like how does that link into that Secret Commissions Act?
Section 5 of the Secret Commissions Act. Because what it says is you got the agent and then you've got the principal, right? So the non-resident settlor is the principal. So the principal's within the courtroom, so he's able to tell the administrator, who's the agent of the Crown, to tell the fiduciary that the trustee is now liable. So if you've gone in there on, say, like, I don't know, might be an assault charge. The charge is no longer yours now, you've just assigned it to the trustee.
Well, the prosecutor's going to love it.
Well, yeah, because the prosecutor is the one you make the trustee.
Yeah, of course. I mean, you may, and they have to. They have no choice but to withdraw it, wouldn't they? They're not going to go after themselves for the same charge. They'd have to withdraw.
Well, yeah, but like in the end, all you turn around and do is go, well, okay, this is what you want done, and so because they're not going to want to put that upon themselves, you just tell the judge, as being the non-resident settler, you tell the administrator that the charge is to be discharged, and you walk out.
Discharge the charge.
Yeah. So therefore, nobody's actually getting done on the charge, right? And you, like, even though they've charged you, you yourself have discharged it through the judge because you've made them the minister. Because you've made him the administrator of the trust.
And so, how do you make yourself the non-resident settlor?
Because if you look up in law, okay, anybody can be a non-resident settlor.
Under what, the Trust Act you were saying?
Yeah, under the Public Trust Act, okay, I think it's Public Trust 2011, I can't remember the exact year, but under the Public Trust Act, you are the non-resident settler.
Because that's
so you assign the duties to the others.
So that's when you're setting up.
It's like if you went to public trust.
So when you're setting up a trust, you can give yourself whatever title you want to and assign titles to other people, so to speak, yes?
Yeah, so like, you know how when you go to like the public trust, the person there turns around and sets up the administration of the trust, sets up the fiduciary, and then you, like, if say, for instance, your parents passed away, right? You'd be the trustee of their estate. However, a lot of people will go to the public trust, get them to set up as the administrator. They'll have someone within the public trust that would be the fiduciary, and you're the trustee still. Under the public trust thing, like when you're doing estates. So basically, what the heck?
Oh, that's me on a bungee down in Queenstown.
Oh, okay. I was going to say.
Me upside down. I was about 22 then.
Oh, many years ago then.
Yeah, very, very many years ago.
But you know, so what it comes down to being is basically how a public trust is set up. You're doing that within a courtroom.
Don't mind my police award. I'm going to give this to the police award for the biggest cock. So whichever cop ends up being the worst cop out there, I'm going to send this to the cunts for the biggest giant blue cock award. It's apparently some Warcraft figure, some orc's cock or something, but just thought I'd throw that in for a bit of humour.
Oh my gosh! All right.
Yeah.
Anyway, yeah. No.
No, I don't sit on it. It's far too. Yeah. Huge.
You sure? Because it's already bent.
Well, it's really funny when you're walking around the house with this holding on. Honey. No,
oh gosh.
Done with it though, I'm sure. Anyway.
But you know, it's done the same way that they set up your normal trust, like in the public trust, where the administrator informs the fiduciary of what the trustee's got to do. Right? So the trustee's going to be the one who's becomes liable for whatever is in front of the administrator. Okay. And so that's how these guys have been getting their way around those sorts of things, is by just turning around and implementing that within a court forum. And so the judge can't overrule it.
So how do you implement it? Yeah, to get
By
your
simply, okay. So what the first part I got told was you just go in and you state, I'm a non-resident settler. I am here to settle a matter. This is a specialist appearance today. And then you just say you're assigning the judge as the administrator, the registrar as the fiduciary, and if it's the prosecutor is the trustee. So the trustee is just taken on your charge. And so therefore, from that point, you're telling the administrator that you want to discharge all the any and all charges through the registrar that the trustee now has liability for.
And the registrar has to do that?
Apparently, yes. There's a few people that have done it, and it works in that manner. Yeah.
Oh, we'll just have to do the old tried and tested manner on that.
Oh yeah, it's one of those tried and tested things. But like it's like how I was looking at the estoppels issues and stuff like that. Yeah, I implemented it on Wednesday, and 80% of the submission gone. It's really hard to be able to have any sort of case when you wipe out their main submissions. They've got pages and pages of case law, but now no pleading to be backed up by case law. So if there's no pleading, there's no case.
So the whole thing should just be dropped. So
no, not dropped. What it means is if you're the plaintiff, for instance, like if you're the defendant, yes, the whole thing can get dropped. If you're the plaintiff, it means that the respondent or defendant now has to go away and relook at what they're going to put forward as a case because you just took their case away from them, their defence.
Mm.
Yeah.
So how do you go about? I know you said you just file a civil suit against the judge.
Yeah.
Is there anything specific, like, for instance, T.M. Black, or is it Timothy?
Yeah, you got to put the full name. So you put the full name of the respondent or defendant, but you put your first initials and so when it comes down to the thing I've been looking into lately is this. Okay, when it comes down to law, then the law is any court case is based on first name, last name.
Sure.
Right. But there is a defence there in regards to first name, last name.
Okay.
So now when we're all born, like for instance, okay, Mark Keane, but Keane is not your surname, it's your father's or mother's surname, depending on how your parental situation was. Yep. So therefore, it's not a family, it's not your name, it's the family name, which is why you used to watch the old movies where they would say, I'm Duncan from the Clan MacLeod.
Yeah, sure.
Because it's not your surname. Yeah, and you get a lot of them that are saying, I'm from the house of, and they'll use the surname.
Yeah, but that's what of the House of King.
Yeah, so but when it comes down to it, they won't accept that. Why?
No.
Because there's a living being in front of them. Right?
And if you say that's what you're commonly known as, they can just use that as an AKA anyway.
Yes, they'll turn around and say also known as, like yeah, you're saying.
Yeah, exactly.
Right. However, what it comes down to is you cannot. This is the part that I'm still looking into a little bit. But how can, like, when it comes to law, you're always referred to on a document as not the living being, but the dead entity.
Of course, yeah.
So how can the dead entity also be known as?
Yeah. So that's the capitis diminutio maxima, where it's all
something
just
along those lines. Yeah, I haven't looked right into it yet, but
capitalization. Or usually the police will go Keane and then Mark Donald Eric, but all full capitalization because they're going after the legal person.
Yes, but the problem is the legal person isn't legal because they're a dead entity.
Yeah. No, you love it. So, call it the complete opposite of what actually is.
Yeah, so when people go to court and they going, I am the living being of so-and-so,
yep,
right? And then they turn around and say,
sorry.
Yeah, so when they turn around and say, like I was reading a judgment where the person had actually said, you know, they presented themselves as being, they were the living being so-and-so of the house of so-and-so, okay? The problem being is, like from what I'm reading, you've got your living being, but the household part becomes an issue from what I'm reading because the household part still has a living being. Whereas if you're going by a father's name or a surname, the surname has come from many generations ago, and so therefore is a dead entity. And so if you apply it in that manner, going by law, then the dead entity cannot be held accountable.
I like how you're going there. That's very bloody sneaky.
Well, I mean, okay, I had a mate years ago who went up on drink driving charges, okay, 1,720 micrograms per litre of breath, right? And he actually got away with this, I think he said it was either 3 or 4 times, right? But drink driving charges, right? No, it was all discharged and no disqualified driving or anything. They couldn't. Because what he did was he turned around, he had a friend that was his lawyer, his friend is a lawyer and was his lawyer. But he asked him, could he take the law book home that he was talking about so he could have a read of it overnight, see if he could find anything. And I said to him, he goes, I walked into the court the next day, up on drink driving charges, lost a license, looking at jail time. And I was like, yeah. He goes, and I walked out a free man from there. He goes, no license taken off me, no nothing. I said, how'd you do that? He goes, because in law, and this was about, 10 years ago now, he goes, at that stage, they still hadn't changed it, and this was from his younger days. And I was like, yeah. He goes, look at the law books in regards to drink driving and alcohol. I was like, yeah. It states within them, any human being that has consumed 1,200 micrograms per litre of breath is to be considered dead. So he walked in, the lawyer went to stand up, he went, I've got this. And he turned around and said to the judge, he goes, I'm going to just state one statement, Your Honour, and I'm going to refer you to your law book. He goes, long as yeah. He goes, long as, and then the case will be over and done with. And he goes, oh, is that right? He goes, yes, that's right. He goes, so he referred him to the page. He goes, yeah, and he told him the paragraph number, line number. He goes, do you read as I do, where it says if a human being has consumed 1,200 micrograms per litre of breath, they are to be considered dead, Your Honour? He goes, yes, it does state that. Right, my only one question to the court, how do you prosecute a dead man?
Because what limit? Well, I mean, what are most people found over the limits?
Well under that, but as he said, if you're going to drink, you make sure you drink till you're well over the limits. He goes to 1,200 micrograms. He goes, because you then consider the dead man, and nobody can prosecute a dead man.
Jeez.
So he just turned it.
That'd be like 15 times the legal limit.
Oh yeah, at least. I mean, like if you take today's legal limit, which is up to 250, that's what 6. Yeah, 6 is 1,500.
Yeah.
So and he was 7, as he said, he was done at 1,730, 1,720, 1,730. But as he said to the judge, how do you prosecute a dead man? I said, what was the judge's answer? He goes, he said his name and said, case dismissed.
Brilliant.
And I said to him, so what did you do after that? He goes, well, put it this way. If I was ever going to drink drive again, he goes, which unfortunately I did a few more times. I was like, yeah. He goes, I made sure I got off my face so I could get off that charge.
Wow.
But it was just interesting to find that out because it made me think when I was reading, I was thinking all the way back to oh my God, that was about 10, 15 years ago when I spoke to him about that. And I just said to him, when it made me think back to them and think, okay, yeah, he said, how do you prosecute a dead man? So if you use the last name going back in your generations, okay, like for instance, at the moment, my father's passed away. So if they're prosecuting me, how are they prosecuting the surname of my father?
Yeah, well, it's my father's still alive. So what they can go.
But then but then your grandfather's dead, aren't they? See, the family name follows through.
Yeah, sure.
Yeah. So how do you like when it comes to that, your the last name is a dead entity because it's been around for many years and generations. Plus, your last name was not chosen by you, so it's a dead entity.
No, it wasn't. So what about people that go through depol and stuff and decide to choose their last name and change it? Then what? Does the ball change?
I would say probably the ball would change then, yes, because you've then chosen your last name, or you've chosen. It's always on the last name. So like you can have any names you want as the first and middle name or whatever your middle names that are, right? But as long as you leave the surname alone, that's a dead entity.
Yeah. Because you'll see, on some forms you'll see the capitalisation just of the last name, usually a colon, and then you just capitalisation of the initials of your given names.
Yeah. I mean, the judgment that I was reading was a public judgment, and I was quite surprised because he went in and he said, "I am the living being this," right? But then he turned around and, like, as soon as I read it, I thought, your mistake is your surname is not a dead entity.
Mm-hmm.
So if the dead entity was there, then they wouldn't have been able to uphold him on it. But then I also found out something interesting from that one, because there was also a driving charge.
And tell no tales, surely. So how can if a dead man can tell no tales, then how on earth can they give evidence or face a charge?
Exactly, yeah, exactly. So it's like, you think about it from this point of view. If a person has debts, when they die, if there's no money, they're like an organization or a business cannot claim from a dead person.
Of course.
So I found it to be quite an interesting thing, because when it comes down to it, when you go into like court cases and that dead entity part is quite a bit of a savior, really.
Yeah. It's sort of a get out of jail free card, that one, isn't it?
Well, yeah. If you implement it in the correct manner, like like I say, you can't turn around and say of like how they did of the house, whatever it was. But that was the interesting thing within that judgment, was that this guy had been pulled up, right, and he'd been done for some driving charges. Okay. Now the interesting part about it was that the judge in that case, the original judge, because this was an appeal, and the original judge, he had turned around and disqualified him from driving. Right. The appeal court said he couldn't be disqualified, as there was no safety issues in regards to the driving. So because there was no safety, and he was up on drink driving charges there, but because he drove in a safe manner, there was no dangerous driving or anything in regards to it. So the court did not have the ability to take his license from him, even though he had drunk driving.
Yeah, because they hadn't witnessed him driving in a bad manner.
Yeah, so they on that part of it, they overturned it and quashed the fact of the disqualification, because they said the court did not have the ability to disqualify the driver, and the judge actually went on to turn around and say, just because the person may have been in a motor vehicle does not mean that the motor vehicle was used in a dangerous manner, and unless it's used in a dangerous manner, they cannot be disqualified from driving.
Because you always hear a lot of people arguing, well, it's not a vehicle, it's a private mode of transport, or it's a private motor car. And if you go back to your old, I don't know if you've still got them, I've still got copies of my old driver's license, where on the back, when you flip it over, it says, one private, a private vehicle.
Oh, the old paper licenses, yes, I remember that.
No, not the paper one, just the last plastic one before the current one we've got now.
Oh, okay, yep.
On the back, it actually just says private, and then it says motor car in brackets.
Yeah.
Motor vehicle. But these days, because we're being treated much more like children, they've gone to what we all see now everywhere, and it's just a cartoon character of a car.
Yep.
There's no words at all anymore. It's just a little beep beep of what a car looks like.
Yeah, but if you've got class 2 and class 4, it has little trucks.
Yeah, exactly. Or motorbike or boat.
Yeah.
They have the little pictures instead. So they're not even defining what class 1 is anymore. It's completely up to your interpretation. You might be reading the card upside down and think the motor car is a strange looking boat.
Well, yeah, exactly.
So, yeah, but they keep changing it. And those little subtle things people don't notice. I actually got my old birth printout. The thing you get before the birth certificate.
Yep.
And it says, you can see that it's the family name. But the most interesting thing I found on my birth printout is that I was entry number 409 of that day.
Yeah.
Right? Now, when you go over to my birth certificate, I'm in district 409.
Oh, okay.
We're all turned into land.
Oh, yeah, of course, because that's what they have to do. That's how they manage to borrow the money from overseas.
That's why the police are district commanders.
Yeah.
And once you start putting 2 and 2 together of how these words have been used to trick, and one word might have several different meanings depending on what context you're referring to it as. So, yeah. That was when I was learning all about the etymology of words. So. But anyway.
But you see, when it comes to those different legislations, even like the Policing Act and stuff like that, right? That's where agent and principal comes in as well. All of those sorts of things, agent and principal. So if you've got, like, you know, when you get pulled over on the side of the road now, right? Yeah. So you're the agent of the Crown is dealing with you, so therefore they can't issue the ticket because the principal's not present.
Because they're only an agent.
Yeah, so they're an agent of the Crown, and the principal has to be able to issue it.
So all speeding tickets are issued unlawfully because the principal isn't issuing them.
Going by the way the law reads, that's exactly right. Okay, but you have to be able, as I found Friday, unless you implement the knowledge, exactly. You're never going to actually get it done.
Yeah. Yeah. So
when a police officer turns around, for instance, and pulls you over, and turns around and says, "I've pulled you over under the Land Transport Act." Yeah. Okay. So where's not where's the senior sergeant? Where's the principal? What do you mean? Where's the principal? Well, you're an agent of the Crown, so where is the Crown representative? Where is the Crown principal? Because until you've got that person here, you cannot give me any ticket. You cannot give me any charge. You don't have authority to do so. You're not the principal.
So what if they say, "Oh, that's fine, I'll just go back to the office and get the principal to issue it out," and some other Tom, Dick or Harry with another 6-digit QID goes and issues it?
Well, the issue becomes at the time of the exchange.
That's what happens with all the speed cameras.
The issue becomes at the time of the exchange, the principal wasn't there.
Yeah, but that's what I'm saying. That's what happens with all the speed camera tickets.
Yeah, but you see, even though you got the speed camera, yeah, but then the agent is operating the speed camera, not the principal.
True. Yeah, but then my little niggle about the speed camera is that the person operating the speed camera has their QID, and then it all gets to bloody Wellington, and then they all get issued from another QID from Wellington as the issuing officer. But in the speed camera deployment handbook, it's the officer that's there must be the issuing officer of the infringement notice.
So the issuing officer from the infringement department, the inquiry I would make is, what judicial capacity do they have? Because an issuing officer must have judicial capacity. Yeah,
well, that's what they say. The issuing, well, granted, I'm not talking about the law book here. I'm just talking about the speed camera deployment operators manual that they have, because I've got.
But in any type of law, a issuing officer has to have judicial capacity. They can't just issue; they've got to have judicial capacity to do so.
So, and that's not getting confused with legal authority, is it?
No, because if you think about this, like a justice of the peace, for instance, okay,
of course,
they're considered an issue. They're considered an issuing officer because they've got judicial capacity. If you're an issuing officer, you have to have judicial capacity to issue the document.
So in other words, a police employee, not necessarily a police constable, but someone on the front counter can't necessarily issue any sort of thing on behalf of the police.
No, because they're not an issuing officer. If they wanted to turn around and issue a fine or something, they can't.
They always say, "I'll get a sworn officer," or "I'll get a sworn constable," because they have the judicial authority to issue.
No, they don't. They don't have judicial authority.
No?
Police officers do not have judicial authority. Only judicial officers do. So in other words, judge, justice, justice of the peace, these are your judicial officers. Only people who can issue warrants and stuff like that.
Okay, so police officers don't have judicial authority, but police constables do?
No.
So, but isn't a constable justice of the peace?
No.
Or an officer?
They're a sworn in constable. So you've got to have the judicial capacity. So it's got to be a judicial officer. I used to think the same thing, but when I read through their Judicial and Crown liability document, what it says is all of them are judicial officers, they're judicial officers, but they're not issuing officers.
Sneaky fuckers. I see. I would.
So you can have judicial capacity or a judicial officer, but that doesn't make you an issuing officer.
Okay.
And so to be able to issue, like how the constable issues the ticket, okay, you take the ticket because the cop gave you the ticket. You don't know that they're not an issuing officer. Like it says on it, issuing officer, right? But when you think about it, when the fine goes, if it's a fine and it goes back to their infringement bureau, it's then got to get, like, if you don't do anything about it, where does it go? To the court, so the judicial officer can deal with it.
Yeah, because then they issue out the notice of, well, that's where it stops from being an infringement notice, which is just an asking, we're sending you a bill basically with the remittance notice at the bottom, and they send you all of that shit first. It's the standard 90-day process.
Yeah, but you could answer that in a letter by stating, I gave no tacit agreement to this.
Yeah, I haven't tried that one. Or I may.
Because the tacit agreement is required. So the officer issues you with the ticket. You didn't agree to take it. You didn't agree you wanted to be fined.
Mm.
So therefore, there was no tacit agreement.
But they'll turn around.
And so the estoppel of acquiescence doesn't come into play because you weren't silent about it. You're saying, no, I'm sorry, I'm not accepting this ticket. But in law, what you're actually supposed to be saying is, I did not accept the ticket and there was no tacit agreement for it.
Even though they'll say, well, you have a current driver's license, don't you?
Yes, but the driver's license doesn't mean that you accept that you're going to get issued with a ticket.
But now, see, that's doing my head in, because
now you know how I feel when I'm studying up on this stuff.
No, it's just they issued the ticket under the legislative powers under the Land Transport Act, under Section 133 and Section 40 of the Land Transport Act, Rule 5.1 of the Road User Rules. They use that legislation. Those are the provisions that are on the speeding ticket. So.
Yep. But number one, they're not an issuing officer. And number two, how did they issue the ticket to the dead entity?
Yeah, I get your point from what you were making, but they'll say that they had the legislative authority to issue the ticket, and it was issued from an issuing officer, because it says that that it's come from the issuing or the issuing authority or the enforcement authority. I think it says on the New Zealand Police. Let me just look at.
But think about it from this point of view. Like I've watched a lot of the ones where they get pulled over in the United States. What is the one thing over here we don't do that they do in the United States when they issue a ticket?
Argue about it.
No. What happens in the States, okay, is they will come back with the ticket and they will get you to sign the ticket and then rip it off and give you a copy. Why?
Yeah,
because in contractual law, both principals have to sign.
Yeah, it's a promise to appear. They will tell you. You're not doing anything wrong. You're not entering into any agreement with you.
Yeah, but when they give you a ticket on the side of the road,
otherwise we'll have to lock you up.
But when they try to issue you with a ticket on the side of the road, the police officer comes back with a signed thing with his QID on it and hands you a copy of it and says you're required to go to court if you don't pay the fine. Well, hold on a minute. There's no contractual agreement because I didn't sign it, for starters. Number two, you're not an issuing officer. Number three, you're certainly not a judicial officer. Yeah. So where do you get that there was a tacit agreement in the first place?
Yeah, but
you're just telling me you're giving me a ticket. There was no agreement to that ticket.
Yeah, but on your speeding tickets, they'll actually call them an infringement fee. They're only fees on the speeding ticket and the reminder. It's once they've gone through to court, then they become a fine, which they can then try and go and enforce.
But at any time, did you agree to pay a fee? No, you did not.
No.
That's right. So therefore, there's still no tacit agreement on it because the tacit agreement requires you to agree.
We'll have to try that out someday and see how we get on. See if we can make a little document.
I mean, like I had the time when I got pulled over by the police just not far from where I live, and I used the card I've got from the primary jurisdiction, and we ended up just going in the end after about 20 minutes. He just accepted that I was not going to turn around and give him a New Zealand driver's license. I had handed him a card from the primary jurisdiction. I told him what avenue would be to deal with it if he issued a ticket. He decided it wasn't worth it for a $55 ticket and said, thank you for the education tonight, and went on his way.
Well, that and the other thing, if he's ignorant of the law, he can't be enforcing it.
Oh, yeah, exactly, yeah.
How can you enforce something if you're ignorant? So Section 25 of the Crimes Act jumps on in there, doesn't it? They're ignorant.
Well, that and the fact that, okay, if you...
If they're ignorant of what they're trying to enforce. Yes?
Well, there's that, and think about this. Then Section 240 of the Crimes Act comes into play because they misrepresented.
Yeah, gaining money by deception, misrepresentation.